Okay, cool. Hi everyone, welcome to the fifth seminar on our Women in Law Society seminars. Today we're honoured to be joined by Sarah and Christianah from Payne Hicks Beach. Sarah is a legal director at the firm and Christianah is a paralegal. She's also alumni at City. Just a quick reminder that the seminar is recorded and will be available on our social media. You can find that in the chat box, and you can also drop your LinkedIn in the chat box if you'd like. We'll also have some time for questions at the end. So just keep them for then, and you can either put them in the chat box when we ask, or you can unmute yourself and you'll be able to ask them yourself. Anyway, without further ado, Christianah, I'll pass over to you.
Hi, thanks for having me and the introduction. So my name is Christianah. I'm 24 years old and I am a paralegal at Payne Hicks Beach Family Department. So I am only 6 months in, which means that I started during lockdown. So when I started, there weren't that many people in the office. So I haven't gotten to meet all the members of the team yet, but everybody has been so lovely and welcoming, and I still got trained as normal. And so I'm just really excited to when we're back in the office in a few months' time to really get stuck in, really.
Here we go. Sarah, do you want to go first?
Yes, hi everybody. Yes. Do you want me to actually sort of embark on my journey into law? Would that be helpful?
Yeah, of course.
So for anybody who's joined, I'm here at your disposal. If you've got any questions about entering law, even though I'm very old now, I'll do my best to answer them. Entry into the profession, what employers are looking for, and sort of what skills are most valued. Please just stick them in the chat box and we'll do our best. Just in terms of my background, I mean, at school, I was massively into public speaking and debating, and I think probably because I hated maths and science. And without realizing, actually, it led me eventually towards the bar. But I was always very interested in politics, economics, and current affairs, not really knowing what to do at school. I then went to read history at Bristol. I graduated in 1992, which was the beginning of a big recession. You probably weren't born then, but it was a big recession, and it was incredibly frustrating because the year before, everybody was leaving and getting jobs in the big milk grounds that used to go around at university fairs. And then in 1992, it just all ground to a halt. So I just started working in Chester, which was the village sort of city where I grew up, starting in solicitors' firms, and then I just really enjoyed being at court. So I started doing mini pupilages in Manchester, Birmingham, and London. I then applied for the city placement schemes at Ashurst's banking firm, Allen and Overy, and that was quite an experience actually, and something I absolutely hated, and it crystallized in my mind that under no circumstances did I want to do any form of commercial law or work in that sort of corporate environment. So I really recommend, if you haven't done that, the only way to sort of really understand, I think, what area of law you're most suited to is to actually go out and get as much work experience as you can. So that was hugely valuable to me. And at the time, I don't know if this is still the case, but at the time in London, certainly there would be sort of 12, 14 pupilages with one tenancy at the end. And only one was funded. So actually it was quite problematic. Unless you could afford another year to live in London, you'd have to do an exam for the funding. And being from the north and thinking that pupillage would lead automatically to a secure tenancy, I then focused my mind on the Manchester bar. And I have to say, at my pupillage interview, I was interviewed by 17 members of chambers at once. So I think that's the thing about chambers, they're very individualistic, and you might have 2 people, as often there were in London, or you might have an entire room of people who are all asking you questions at the same time. So it certainly helps if you're familiar with the set of chambers, and I was, because I'd done a mini pupillage in that set of chambers. So for anyone going to the bar, mini pupillages, familiarity with the main practitioners in the areas that you're interested in are really, really important. So that was my year out. And then I did the conversion course at the College of Law, which I have to say I found really utterly tedious. But then I went back down to London to do the Inns of Court School of Law, which was really enjoyable, and the teaching was very, very relaxed. You'd literally get the barristers coming in after their day at court and giving it advocacy sessions, drafting sessions. It was a very collaborative environment. There was none of the sort of accountancy exams that my solicitor friends had to do. And it was a massively enjoyable year. And part of that enjoyment was also belonging to the Inn, which was a hugely sociable venue. You had to do your dinners, 24, I think, at the time. And it was a place of learning. And the Inn then, and it does now, offered really impressive sort of support. And part of the support that they offered was a marshalling scheme. And I'm sure they still offer this marshalling scheme. And I was so lucky, I applied for it, and I marshalled 3 High Court judges, and I stayed in the lodgings for about 2 weeks up in Manchester. And with Mrs. Justice Steele, Mr. Justice Curtis, and Mr. Justice Pill. And every evening you go back to the lodgings, you talk about your cases, you do preparation for the cases the following day, you'd read the cases, put a case summary together, you'd travel in the limo to court with the High Court judge, and you'd sit on the bench with the High Court judge. And it was an incredible experience in looking at the courtroom from the bench and learning to see what is it that the judges really value in terms of advocacy and presentation. So again, whether you're going down the solicitor route or the barrister route, all of these experiences are really important in crystallising. Well, they were important for me in crystallising what I wanted to do. So then I started at the regional bar in '96, I think, and it was a hugely vibrant bar. I know I feel very London centric now because I've lived in London for so long, but the Manchester bar is just hugely vibrant, and it had giants in the legal world. So you would often be before Brenda Hale, for example. I mean, that was just our judge as you turned up, or Mr. Justice Wall, Nicholas Wall, Joyanne Bracewell, there was Mr. Justice Ryder. These were just, you know, our everyday of going in and doing your applications and your cases. A colleague of mine from Chambers now is Mr. Justice Poole, who's just been promoted to the High Court Family Division. So it was a bar of huge figures, and it was very, very exciting time. And I did a common law pupillage, so I'd be going from PI to crime to family, and there was no formality about it at all. You would literally just turn up and you'd say to the clerks, what's the most exciting thing going on today? And they would sort of say, go and help so and so. And I don't know if it's like that now, but it was very much like that at the time. And my head of chambers was Mr. Justice Rodney Cleven, who became Mr. Justice Cleven. He was briefed, a very successful criminal QC who's briefed to represent Fred West, for example. And it was just a very exciting time. And then there were the Bulger killings, and the trials were held in Preston. There was the Shipman trials. You didn't know somebody in Manchester that wasn't affected by the Harold Shipman case. So it was just an incredible time. You were living and breathing law, literally, every day. And it absolutely wasn't this sort of sleepy bar that perhaps some people think. So I did a lot of criminal work. Manchester still like their armed robberies. When other regions had moved on to fraud, Manchester stuck with armed robberies. So there's a lot of visits to prison. We prosecuted more than we defended. There was work for customs and excise. I have to say, what stands out for me was the criminal plea day on a Friday, where you'd be handed 12 pleas in mitigation as a junior barrister, and that you'd wait for the prison van to arrive and deliver the prisoners to the bowels of the court. And then you'd have to interview and take instructions from all of your prisoners and then be back up in court by 10:30. And the speed with which you had to meet somebody, gain their confidence, absorb information, take their recent instructions, and prepare a plea of mitigation was sometimes minutes, literally minutes. So it was an incredible training, if you like, in terms of just what is important, what are the most salient facts of this case, what do I need to convey to the judge. So yes, anyone wanting a high adrenaline environment, something like that, I recommend. And then gradually I drifted away from crime, and partly for personal reasons, because I was beginning to have my family, and the diary for any criminal lawyer is just completely erratic. You could have a 5-day trial in Winchester, then you'd be back, you'd have a big trial, then someone would plead guilty. And it's just very, very difficult diary to sort of control, whereas a family diary is much more stable and you could plan better in advance. So I drifted more towards the family, doing a lot of care work, a lot of serious injury care work. I acted for the guardians, the official solicitor. The official solicitor briefs were amazing because they were beautifully, beautifully prepared. And when you're acting on behalf of the official solicitor, you're taking the government line. So whenever there was a dispute that required government intervention. And then on the back of acting for the official solicitor, I then got promoted to Junior Counsel for the Crown. And it was also a time where it was the rise of the super divorce. Big money, big money coming into Manchester. So the recession is now over and we're now into big money territory. And it's not quite white and white territory, but it's the wives asking, actually, I do want more than 20% of the matrimonial assets, and the rise of the prenups and the rise of the foreign money coming into London. So you have the influx of the Russians. So the case law is really shifting and really changing. So I did more and more family work, and it was, again, it's not the same adrenaline in terms of criminal law, but it was a very exciting environment. And you were just every day in court. So your arguments and your advocacy and your skeleton arguments were just constantly being refined in a way that if you're a solicitor, it's very, very different. And that's something that is very striking, because obviously I'm a barrister, but I'm now in-house effectively working as a solicitor. So that was it really. So the family law was very, very exciting. And then I left the bar at a time when I think my career was really getting established, because we had to relocate abroad. And then when we moved back, we didn't move back to London to my old chambers. To Manchester, we moved back to London. And I didn't know where to start in terms of looking for a career. I had been out of the legal environment. And during that time, I did a lot of volunteering with the NSPCC. I gave workshops for how to keep contemporaneous records, for example, for the social workers, so that they presented cogently in court. Court presentation workshops for the NSPCC. I worked with Mind on the introduction of the Welfare Reform Act. So, and I work with citizens advice. So the whole time I was keeping abreast with legal, I suppose, legal and political and economic developments as best I could. And then when I looked to re-enter the workplace, I ended up working at a UK-US law firm and going full back into family law on that, and have stayed in family law ever since. So now my role is very much about, it's about obviously advising the client, but client care is very important, and gaining the trust of that client and advising them to the best of your ability, advising them as to how best they can run their case. Do they have a case? Do they need to settle? What do they need to be looking at? What factors would the court take into consideration? So it's very different to being at the bar. And now there's a huge emphasis on, quite rightly, on settling cases at an early stage. So all the way through, there are protocols to consider mediation in the absence of domestic violence or emergency, for example, to consider mediation and arbitration. So now it's a less adversarial approach in family law, and it's a more collaborative approach. And there are rise of sort of pilot schemes, for example, where certainly in high conflict parenting disputes, which I do a lot of, the courts are looking at early intervention. How can you prevent it becoming a high conflict dispute? Because often by the time the parties come to court, it's too late. They are so entrenched in their view that actually it's very difficult to facilitate a collaborative approach. So that's my sort of career. That's where I am. What I will talk a bit about my individual specialism, which is surrogacy and modern family law, because I see that as really the cutting edge of family law now. But what I would say is to really get involved in all the societies, and like this women's society, I think it's fantastic. It offers a chance for you to discuss amongst yourselves how you can best support each other. Where are the barriers? What can you do about those barriers? Can you raise awareness of those barriers? And it's a different world now, and I think reach out to mentors, reach out to marshalling schemes, reach out to sponsorship schemes. And there are some incredible websites out there now. So it was quite difficult back in the day to sort of be abreast of current legal developments. If you weren't in a chambers physically, or you weren't near the inn, you couldn't just tip up at a law library if you lived in the middle of nowhere. Whereas now some of the chambers have super sophisticated websites. I'm a huge fan of 39 Essex Street for anyone interested in human rights, court of protection work. They have incredible podcasts, webinars. There are fantastic podcasts out there. Ones I listen to are Crown Office Row, One Crown Office Row, Law Pod. There's the Joshua Rosenberg, there's the Legal 500. So in terms of just surrounding yourself with law and where it's at and where it's going and how can you be part of that conversation, I really recommend sort of accessing those sort of resources and making the most of them. And then in terms of the INS, they are massively supportive of the younger generation. They are very aware of the barriers to entry of law. They are committed to diversity and inclusivity. And I think there's a reason, that you have, within some law firms, you have the LGBTQ groups, is because people enter into law as a profession. They advocate for change. And it's not a profession to shy away. If you've got a cause that you want to advocate for, you're in the right profession, and go ahead and do that. Find your voice. So use the INS. I can't speak, maybe Christianah will be able to help about sort of the Law Society and things like that. I'm no good on that. But do write in, do get as much work experience as possible. The other, for webinars, also Chambers One Garden Court have fantastic webinars. Thought Leaders 4 is another organisation that do fantastic webinars. And I think just certainly hunt around the Chamber's websites for the area of law that you're interested in, and you will find podcasts and webinars that will just be invaluable, I think. I think there's also, in terms of neurodiversity, there are huge movements to include neurodiverse applicants to the profession. There's a 93% club, I don't know if you're familiar with this, for pupils of state schools, and they run fantastic events. One event that I never miss every year is the Doughty Street Women's International Day Conference. It is unbelievable and free to join. You can usually attend in person, but this year, or for the last couple of years, it's been online. It's just a mine of incredible women that are truly inspirational, and how they use law to better the lives of others. In terms of family law, there's the Coram Children's Centre. Chrissy, are you familiar with that? Coram. And I think, sorry, I'm just looking to see what else. LinkedIn is a good one. So yeah, I think the resources are out there. It's just about accessing them. And perhaps I hand over now to Chrissy, who will tell you about her entry into law.
Okay, thank you, Sarah. So I don't really know where to start. So I did my LLB at City University of London, obviously. And whilst I was a student, one thing that I always did was I was very interested in student enterprise. So what that meant was I was constantly getting involved in society. So I was on the committee of the Law Society, and I found this was just a really good exposure for me. Not only was it a good networking, not only was it a good way to network, but we were basically liaising with law firms in order to get them to come and deliver talks and workshops. So we had that direct contact with law firm recruitment. So from that, you can create a relationship with them, and you never know, it could lead to future job opportunities as well. It's just I just found that a really, really good way to network. Obviously, aside from that, you get to host these events, and it's informative for yourself as well. So yeah, apart from that, I was also a mentor to like first year students. So City is predominantly an international university, so a lot of students are from abroad, and it's their first time. Sometimes it's their first time in London. So the uni has created a City Buddies scheme, which is sort of a way to sort of help them integrate better with the student community. So it was really, really nice to meet other people with different cultures and learn from them as well. I found that really interesting. And thirdly, I was also a marketing student ambassador, which was just a really good way to earn some like part-time, earn some money part-time while studying, because some of these law books are very expensive. So so it was you know, really good, and it was well paid. And again, networking, because I know a friend of mine, she got a job in the marketing department, and that was through her being a student ambassador. So it you know, it's just important to just put yourself out there, because you never know what it could lead on to further down the line. Because I know for a fact that the marketing department, they do look at the people who are ambassadors and who get promoted to senior ambassadors, and they're always recruiting after like 2-3 years. So they are going to be looking at you if you've got a good track record. So it's just really important to put yourself out there and make sure that you're getting involved as much as you can. And yeah, you never know where it can end up, basically. So I guess that would be one advice that I would give to people. Get involved with the societies, get involved with the voluntary positions, and just get involved as much as you can, but also balance it with your studies and make sure that's not that your studies aren't suffering. It's all about a balancing act, but it's easier said than done, because it is very difficult. You just have to be careful not to spread yourself too thin. I was actually guilty of that in my first and second year. you sort of need to know when you have enough on your plate. But yeah, so it's sort of it's obviously going to be your judgment call, but yeah, get involved but not too much.
Yeah, and I do think that actually you can use things in your personal life. So if you're applying for, I don't know, a statement of special needs for somebody within your family, for example, that is a prime example of battling the system. So all of those sort of things actually are prime interview material in terms of how you have advocated on somebody else's behalf. You've understood what the parameters within which you must argue, or the parameters over which you must argue, and really push yourself out. So don't, if you haven't got time to sort of belong to a sort of sophisticated organisation, just look at what's happened within your own life, or the difficulties that you yourself have faced, and maximise or use those to your advantage in this sort of situation.
Definitely. And I think one thing that Sarah mentioned that I think is so important, and I would say was very significant in like how I got to where I am, is to find a mentor. I think it's very important to have a mentor in the legal sector, because they will advise you, they will guide you, they will tell you things that will actually make a difference and will help you. Especially like, you know, an individual who's from the BAME community, you may not have links to the legal sector, you don't have that access. Obviously, there are organisations like Aspiring Solicitors who offer diversity access schemes, but there's only so much you that can do. Sometimes it's really important to have a mentor who's currently in that sector, and they can tell you and just, you know, help you out basically. So I think having a mentor is very, very important, even if it's just confidence, if it's helping you to get well connected. Yeah, I think that's really important, and LinkedIn helps with that as well.
Actually, the inns all operate a mentoring system, and certainly in the past I've prepared people for pupillage interviews, and I've read their pupillage applications, and I've done mock interview type questions. So mentoring is really important. And actually, just whilst I remember, there are organisations such as Women in Law and Women in Family Law, and you will find all sorts of organisations like that that will be able to assist. Is it worth looking at any questions?
Do you want to start questions now, or Sarah, did you say you had a bit to say about your...
Yes, should I do that?
Yeah, that would be... Yeah.
Okay, so I don't mean to indulge. If you're not remotely interested in this area of law, switch off, but I'll just whiz through it, because if you are remotely interested in family law, this is the next stage of family law, so it might be quite interesting to you. Now, I'm going to have to do this thing called share screen. Can you see it? Oh, hang on.
Yeah, we can now.
Can you see it?
Yeah.
Yeah? Okay. So I'll whiz through it. But quite interesting. So 50 years ago, abortion was a criminal act.
Oh, hang on. If you just click on your PDF, because we can't see the PDF, we can only see your desktop screen.
If I do new share.
Yeah.
Hang on. Does that work?
Yeah, brilliant.
Okay. So it's a really quick whiz through the legal history since 1967, when abortion was a criminal act. Homosexuality was decriminalised. So huge legislation happening then in 67. Then you have the Human Rights Act of 1988. Massive implications, obviously, but especially in family law. Then you have adoption, the Adoption Act, 2002 Adoption Act. And actually, I should go back, because that has been extended enormously. It used to be very restrictive on who could adopt, but now single people can adopt. So that's a huge development. Then in terms of surrogacy, you had the first commercial surrogate baby. I actually remember this in 1984, and it was a mother who entered into a surrogacy arrangement with an American couple to give them a child for a sum of money. And it created an absolute storm at the time. And she was vilified in the press, actually, Kim Cotton, totally vilified. It was the sort of babies for sale headlines. And in fact, she was married at the time, she had children, but she felt she could provide a child for another family. And the result of that Kim Cotton episode, they brought in the Surrogacy Arrangements Act, which made it illegal. Commercial surrogacy was illegal. And then there was a Warnock inquiry which investigated how on earth could this happen? How can we stop it again? It's appalling. And then you go to the Human Fertilisation and Embryology Act 1990, which then defined the remit of surrogacy, and it was thereafter permitted on an altruistic or compensatory basis only. So reasonable expenses were paid, but absolutely you cannot pay anybody if there's an element of profit. And it created this thing called a parental order, which is the equivalent of an adoption order, whereby a child born of a surrogate, in England, the surrogate is deemed the legal mother of that child, not the intended parents. So you have to then apply for a parental order, which extinguishes the legal motherhood of the surrogate and confers parental rights on the commissioning parents. Then you have the Updating Act of 2008, where parental orders were extended to same-sex couples. That's hugely significant legislation. And yes, so that defined the legal mother as the woman who carried the child, even if no genetic affiliation. And yes, you've got the parental order. And then there was a single parent who wanted to have a child through surrogacy, but they couldn't because the act was restricted to couples in an enduring family relationship. And so this went before the courts. It was found that a single person should be eligible to apply for a parental order. There's a declaration of incompatibility with the human rights legislation. And so from 2019, single individuals were eligible to apply. Sorry, keep going backwards. Payments to the surrogate still remain banned. There's just been a massive surrogacy review. They are still going to remain banned. It's part of English public policy. It is quite problematic because it means there are not enough surrogates, but it's a firm, it's a bedrock, if you like, of English public policy. And it unfortunately does mean that those who have means go abroad to California and Florida, enter into a fully all singing, all dancing commercial arrangement. And those that don't are restricted to waiting here for a volunteer surrogate to come available. So I see it as still being quite problematic. Then just quickly, in terms of posthumous conception, when I was at my previous firm, Vardags, we had a case of posthumous conception, and it was really, really interesting. The first case, you won't remember this either, but Diane Blood, that was a really extraordinary, it was the first time that posthumous conception ever came before the court. It was a 2-year battle. I can't remember what he had now, but he was in a coma and he was brain dead. And the wife won the basis to have fertility treatment using his sperm in Europe, but not in the UK. And she did have a child. Then the next case was Beth Warren. The husband has frozen his sperm age 30 before starting cancer treatment. It is a treatment that is offered. But he died as the storage for his frozen sperm. Oh, that's right. And then, yes, he died, that's right. And Mr. Justice Hogg, yeah, agreed that he could have the child. That's right. So you can see that the law is developing. So Mr. Justice Hogg is relying on what were the wishes of the father when he was alive, not looking at the written consent, because when you're going to fertility clinics, you have to fill in quite detailed written consents. Then you have, while Warren and Blood were fighting HEFA, the Human Embryology and Fertilisation Authority, to have the right to keep their husband's sperm, Mrs. Jeffries was fighting to stop her already created embryos from being destroyed. So her husband died aged 32. They had 3 embryos stored. They were in the freezer whilst he was alive. But the storage of these embryos had expired. Honestly, the nightmare of forms and storage expiration dates is hugely problematic and forms most of the law in this area. It was a clerical mistake that the husband had agreed to 10 years storage, but in fact the firm had only referred to 2, so the clinic was saying that the storage was out of date. But Mr. Justice Mumby, who's a great proponent of modern family law, allowed the use of the embryos. Now, this was a case that actually came before, was in my firm, my previous firm. And it was where the husband was catastrophically injured in a road traffic accident. He was in a coma, and they had already had 1 child through fertility treatment. And they were in the process, the husband and wife, of going through fertility treatment again when he was catastrophically injured. They had discussed posthumous conception, but he couldn't provide consent because, of course, he was in a coma. So the wife went to court, and she went to the Court of Protection before Mrs. Justice Knowles, saying that his sperm should be used lawfully for use in fertility treatment, and that was allowed. So it's really at the cutting edge now, where you have somebody who's in a coma and you can use their gametes without their sort of conscious consent. Then this one, illegal posthumous conception. 26-year-old man killed at a road traffic accident. The body was not discovered for 2 days. This was all over the papers. I don't know if you remember it. Wealthy parents wanted an heir to the fortune. They engaged a urologist to extract the sperm from the body by the side of the road. It was couriered to the US. 4 embryos were created, and the child was born in a Californian clinic in 2015. And it only came to light after, well, when the child was literally a toddler. So people are going to extraordinary lengths and ignoring the law. If they want a child or they want an heir, there are ways around it. Then I don't know if you've done this on your courses, but Gillick competence is where you assess the competence of a teenager to make decisions. And it was introduced by a woman called Victoria Gillick. Have you studied this at all? No. It's really important, Gillick competence. And it was, it undermines all the transgender laws now that are dealt with in the press. It's the questioning whether an adolescent actually is competent enough to make serious medical decisions. And it's called Gillick competence because of a woman called Victoria Gillick. She was a Catholic mother of 10. She a leaflet advocating contraception for under 16s without parental consent, and she was furious. And she went to the High Court. And the test in the High Court was a child must not only have the ability to understand the nature of the proposed treatment, but a full understanding of the consequences of the treatment while possessing the necessary experience of life to make that decision. So that's quite a test when you're young. And this was in relation to the contraceptive pill. So you imagine it now in the background of puberty blockers. It's another level. So that's the case of Kira Bell that wanted to transition to male. After 3 one-hour appointments and male hormones, she had a double mastectomy. She is now detransitioning. She lives as a woman, but she's left with a deep voice, facial hair, and impaired sexual function. And she was effectively suing the Tavistock Medical Trust saying that she should never have been allowed to make those decisions of such gravity, and they are irreversible. And so the issue for the court was, did Kira have the necessary capacity to consent? So perhaps, so then you also have the Gender Recognition Act. So people are being allowed to legally change their gender with a gender recognition certificate. You also have 3-parent babies. So family law is not just a question of divorce and children disputes. 3-parent babies are with gene editing. It's to prevent fatal genetic disorders. It's very, very tightly controlled in this country. But in fact, you don't have 3 parents named on the birth certificate. In England, you only have 2 parents. You can only have a maximum number of 2 legal parents. And so you don't actually have 3-parent babies. It's just for the creation, they use a donor. So the legal cases put by Kira Bell on Gillick competence is, she's asking, can a child consent to forego capacity for adult sexual pleasure before it has even begun? So it's just like the gravity of these decisions that children are being asked to make, and where does the court sit on that? And then, can only a mother give birth? I don't know if you're aware of this. Freddie McConnell, who was female at birth, transitioned and then registered as male. He was biologically able to become pregnant. At the time of the birth, he had legally become a man. At the registration of the birth, the law requires that whoever gives birth to the child is a mother. And he sought judicial review to be named on the birth certificate, and he lost in the High Court and at the Court of Appeal, but that's coming back. So that's the end, but it's just a snapshot of the seismic changes in family law that are happening at the moment. And that's the same in every area of law. It's just moving at such a fast pace, and it's taking into consideration cultural, societal, political, economic changes. So it's important to sort of be widely read, I suppose.
Are we ready to go for questions now? Or,
yeah.
Okay, so yeah, if anyone has a question, you can either type them in the chat box, or if you want, you can ask yourself and turn your microphone on. So yeah, well, I thought I'll kick this off with a question for you, Sarah. I was just wondering, obviously you see a lot in the press now, a lot of celebrities in America are paying for a surrogate. So it's obviously a lot more liberal with regards to that in America. Why is it that in the UK they're kind of more constrained on commercial surrogacy?
It's just part of public policy, and there'll be a religious element to it. There always is. Surrogacy is banned in most of the Catholic countries in Europe. Italy, a lawyer can't even touch a surrogacy contract, for example. In Italy, it has criminal sanctions. And here, in fact, the Surrogacy Arrangements Act, which is still good law, carries criminal sanctions for lawyers for negotiating a surrogacy contract. So there will be a degree of religious position, but it's the idea of women effectively selling their bodies.
Right.
I struggle with that in terms because I've represented women that have had cancer, and it is their only child. You know, they are rendered infertile, and it is they've stored their eggs before, and it is their chance to have their biological child. So I struggle with that. Yeah.
Do you think that we're looking forward to it changing, or?
No, there's been a huge law commission, and it will remain altruistic and compensatory, but commercial surrogacy is going to stay.
Oh gosh, okay, that's interesting to know. Yeah, thank you.
It's very, like I say, it's very difficult for those without means to pop abroad. That's where it's unjust, if you like.
That's insane. Do we have any more questions? If you have any, you can pop them in the chat function, or you can just put your hand up and you can unmute yourself and ask. I actually had a question for Christianah. I'm not sure if she's still there. Oh, we've got another question in the chat, but we'll get to that in just a moment. I actually wanted to know more about your role as a paralegal. So what sort of responsibilities have you been able to take on?
Okay, this is a really good question. So I've despite only starting 6 months ago, I have been involved in quite a few cases already. So like typical duties would be sort of drafting questionnaires, drafting chronologies, doing a lot of my work does involve, it is mostly admin and drafting work. Other stuff that I do is sort of telephoning the courts to sort of seek an update on our client's case.
Good luck if they answer, Chrissy.
Yeah, most of the time you're on hold for like ages, but yeah, you still have to sort of get that update.
It's far better if you can go in person.
Yeah, exactly. That's what I'm looking forward to when we're back in the office in June, because it is honestly better in person. So yeah, other stuff that I do is I prepare/create court bundles. I draft documents such as statements of issues. I produce attendance notes as well, which can take place between the partner or solicitor and their client. Or sometimes it's depending on where the case takes place, it could be with an expert in a different country. Attendance notes on that. Contacting clients via email or telephone to take instructions from them as well. That's pretty much sort of my duties that I do as a paralegal, but I'm really enjoying it. It's very interesting. I'm very, very happy to be here as well. And
I think that's very different from the sort of city experience that you get. When I was doing those, I appreciate it was only those vacation schemes, but you felt that even as a sort of newly qualified, you were very, very small cog in a very big machine.
Exactly.
And the idea that you would have any contact with the client, or I remember sitting down, it was very much sort of proofreading documents for spelling mistakes and a lot of photocopying. So you have to see beyond that. Obviously, it's a different trajectory, but it's not immediate satisfaction in terms of client care.
We've had a question from Andrea in the chat. She says, good evening. In what other respects do you think the Law Commission fails short of achieving a significant reform that's able to address the current issues? That's in regards to the commercial surrogacy thing.
Well, I hope that they raise the profile of surrogacy. I think they will. I was speaking to the MP, Andrew Percy, about this at the parliamentary group committee last week, and I think it's a missed opportunity. I have a podcast coming up about this with an intended parent, if anyone wants to listen to it, and he's also furious about the lack of, he desperately tried to have a surrogate in the UK, and he just could not find one. So I think they've missed that as an opportunity. They need to really promote surrogacy, and for it not to be taboo. It's just a massive opportunity that they've missed there, I think. It's as long as commercial surrogacy remains a barrier, it brings with it it restricts the accessibility for others. So I think it sort of keeps it under the carpet, and it's a terrible shame, and surrogates won't come forward as a result.
We have someone with their hand up. Would you like to ask your question?
Yes, so my question's for Sarah. we heard about your experience moving from crime to family, and the fact that the diary is more manageable. But if there was one other thing that you could tell us about that you really, really enjoy about family law, what would it be?
Well, I mean, it's just, you are pivotal in making decisions for, you know, you have an enormous role in speaking on behalf of somebody and on the most important thing in their lives, which is their family and their family dynamics. And if you're doing care work, that means it can mean their child living with them or being taken away from them. It can mean the difference of, you know, having a relationship with your child or not. How to spot parental alienation. Family law is now so sophisticated in terms of the experts that you bring in and the dynamics and family therapies and dealing with addiction, anorexia. It's not just about divorce and simple contact disputes. It's a huge remit, and a good collaborative lawyer will work with other lawyers and with other experts to bring about a solution that the benefit of the entire family, not just for your client. That's the idea. So it's a very rewarding, as I say, it's far less adversarial. Obviously, you're going to get the huge Russian titanic battles over the multi-million-pound fortune, and they'll always be there. But the majority of cases are, it's after the courtroom door is shut, the families still have to speak to each other. And I had this very recently, actually, on a court of protection case where it was an end-of-life matter. And the hospital wanted to turn the life support machine off. And we mediated a settlement for a drug to be administered and on a protocolized trial. And that was just it was a very rewarding experience. It's not just about, some of these arguments are quite subtle. It's about having the opportunity to do justice, and balancing where that justice is for, not just for the family in my matter, but for other patients in a similar scenario, and setting a sort of precedent with the hospital. Actually, if these are the situations, you shouldn't be turning the machines off without due process, without, you know, a transparent due process. And that was quite a significant agreement that we reached. So more and more, actually, I think it's sort of less adversarial and it's sort of problem solving.
Thank you. Could I ask you another question, or do we need to move on?
Go for it, go for it.
That's to do with law, but you know how you told us about the break that you had where you went abroad and came back. How many years were you actually out of the career, and what made
I was out of law for about 10 years, but that was in a working capacity. But as I say, in that time, I was often volunteering. And when I came back to England, that's when I did a lot with the NSPCC in mind and citizens' advice.
Okay, yeah. Was there a reason why you didn't go back into bar straight away, or was that just a choice?
I think that was down purely to personal circumstances. I had 3 very small children. Both my parents died, so there was a lot going on, and then my youngest son needed an operation.
Yeah.
And yeah. I think it's interesting. We talk about this quite a lot, actually, at work as colleagues. It's quite a difficult job to do part-time. Mm-hmm. And I think that is one thing in terms of lifestyle that actually is quite limiting. Your clients want you all the time. They want to be able to reach you all the time. And family law is one of those, family or criminal or most areas of law. You need to be accessible, and it's very difficult to just say, actually, I'm not in on a Thursday or a Friday. So when you make a decision to sort of re-enter the workplace, I think it's difficult to do it other than full time. There are people that work 4 days a week, but I think that's difficult.
Yeah, Thank you. Apologies for going so in depth about the personal side to it. It's just that I've just started, and there are some ideas of moving abroad, and I just wanted to know how it all kind of happened for you.
Honestly, if the one thing I would say is try and just keep it ticking over. Just keep the law ticking over, because it's in the same ways that there are barriers to entry now. It's very difficult to re-enter the workplace. It's not easy, and so I think you've got to add value for that time that you're out. You've got to make it count, and it's got to be productive. And re-enter where it's something that you're passionate about.
Yeah. No, thank you very much, Sarah. That those are my questions. Thank you.
There's lots of international organisations as well.
Yeah.
So even if you move abroad now, actually, there's a lot.
Yeah. Before I came to the bar, I used to work for human rights NGOs internationally, and I thought maybe I could do a bit of that, but then I do want to establish myself first and then perhaps think about that.
Yeah, establish your network, definitely.
Yeah. Thank you so much.
Pleasure.
We have another question in the chat. It's for Christianah. Are there any skills you wish you developed prior to joining Payne Hicks? And are there any factors you wish you took into account when you were applying for firms?
Okay, that's a really good question. So I haven't done my LPC, so I wish I had. So I would say the two skills I wish I had developed was perhaps my IT skills. I'm not saying I have bad ones, but just sort of like knowing that maybe an advanced level of how to use Excel spreadsheets. Like, you'd be surprised how much you have to use these. You'd be surprised how much of your IT skills you need as a paralegal, and that you are going to need to know more than just like the basics of what you got taught in like when you were in secondary school. So I wish I'd sort of brushed up on my IT skills a little bit, and also I wish I had more experience of drafting. So luckily in my final year I had picked what module did I pick that I was able to do a bit of drafting? I think it was, oh God, I don't remember now. I had David Amos, who is the director of the LPC course. I think it was legal skills. I think it was legal skills and legal ethics. Anyway, we did a bit of drafting there, but obviously when you do the LPC, you go into depth about how to draft like letters to clients, law firms, etc. So yeah, I wish I sort of had more experience of that. And so yeah, those two. So my IT skills and drafting. And in terms of the other thing,
I think IT is really, really, really important. I mean, I've never ever put a bundle together, but it's hugely important. Yeah. And that the people, the individuals that can put a bundle together and at speed are highly, highly regarded.
Definitely.
It's really, really important. And also, even if you're drafting instructions to counsel, for example, and there's tables that you want to put in to present a chronology or information, actually some people will just be able to whiz up a fantastic table that presents things in a really clear way. And I'm certainly not one of those. My formatting, all of that's horrific. But again, it's something that you hugely value. Presentation, Word, advanced emails, delay send, all of these actually, I don't know if you can do courses on
you can
Outlook and Excel, but hugely valuable whatever area of law that you go into.
There was a second part of that question, which was, are there any factors you wish you took into account when you were applying for firms?
Okay, that's a good question. Factors I took into. Okay, I always wanted to know what their ratio was in terms of how many women were in senior positions, and also their BAME statistics as well, because I want to be at a firm, obviously, where, like I don't want to be the only, minority there. And I also want to know that the law firm is diverse. I think that's really important. I always took diversity into consideration. And also I took into consideration the firm's retention rates. I think that's so important. I mean, there's no point a law firm recruiting about 50 trainees when they only keep 10. That's not really good. And one thing about PHB that I was so glad to hear was during COVID, they didn't let go of any of